Okay, Shannon, you can put us back on the record.
Okay.
Were there any further questions for Mr. Jaros, Mr. Thompson?
Yes, Your Honor. Go back over a couple things from trial. Number one, Mr. Jaros, the question I sent to you of whether any of the improvements had been made by Mr. Mason between the time you guys separated your relationship on the 13th and he agreed to perform some other items and the date that you received the lien on August 10th. And your answer to that specific time frame was no, correct?
Correct.
Later on, there was the items were finalized, correct?
Correct.
And later on, after strike that, we'll hold that for later. Now, question then become the question was frustration over the slow pace. Contract was started in April. Did you have a conversation with Mr. Mason about expected time frame and completion?
Yes. Along with two others, there was a discussion as to when this would be.
Mr. Jaros, let me have you start over again. It was a little garbled at the beginning of your answer.
The question was there a discussion at the time? We'll back up. At the time the contract was ended,
I heard the question. What was garbled was when Mr. Jaros started to respond. Make sure you're looking right at the device when you speak, because it just didn't pick everything up.
Okay, I was saying, yes, there was a discussion on April 13th of 2018 with two others present. That was a Friday. And the discussion was when we might be able to first stay in the property. And it was answered by Mr. Mason the last week of May or first week of June of 2018.
and was that time frame met by Mr. Mason?
It was not met by Mr.
And did that cause friction?
It did.
I'm going to draw your attention then to exhibit number 20, please. And that's your exhibit. And this is some email communication that you had, is that correct?
Correct.
And actually, the email communication starts at the last page, but it looks like it's a 5-page exhibit, is that correct?
Correct.
What was the purpose of this email communication in May?
The purpose was discussing the flow of work and timing when things could start to get scheduled.
And was this past the point in time when you were expected to be able to take possession based on Mr. Mason's comments?
Yes.
And what was the gist of the issues that came up?
I had some cabinetry that was ordered in March, and we had delivery scheduled and the countertops scheduled, and they were saying if we did not accept delivery, we were going to start incurring inventory costs. So I needed to have the electric and the work, the drywalling and so on, the plumbing ready for the cabinetry to come in.
And under the contract with Mr. Mason, it was, strike that, it was not in the contract with Mr. Mason that he would do the cabinetry and the countertops, is that correct?
That's correct.
And so drawing your attention then to the very page 1 of the 5 pages there, specifically on your email of May 2018, what was the purpose of that email?
I realized that late May, early June date was not going to be met. So I just wanted to ask, what was Mr. Mason's projected timing for the framing, the plumbing, the electrical? And I was saying the paint, floor, installation, because it appeared that no one was showing up week after week as we'd come up to the cottage. Visiting my parents who live down the street, there was no progress being made. So just trying to get a timing when it was going to happen.
Do you have any understanding as to why nobody was on site during this time frame?
I did not.
Did you make any inquiry to Mr. Mason about why the lack of progress?
I did, and you could see just, he responded by saying nothing was going to happen until May 31st. No one could be there. Evidently he couldn't get his suppliers there.
Suppliers are a subcontractor?
Subcontractors.
And was that consistent with what he had told you on April 13th?
It was not, and that's why the frustration level was increasing.
That was in the May timeframe, is that correct? Now, you were asked a question about the siding and why you did not say anything to Mr. Mason when you saw the siding in the debris trailer, is that correct?
Correct.
And what was the intent under the original contract with respect to that siding?
The intent was input the sliding door, and the sliding would go back up as existed before the door was put out.
And did you have any discussion with Mr. Mason about the siding at some point?
He had mentioned to me that in his opinion, the siding was old and we might want to consider different siding. And we had mentioned, please provide us with a quote before we make that determination, whether we'll go with new siding or just reinstall the existing siding. Provided a quote
for new siding.
For new siding in mid-July, after the old siding was long gone.
And what was your response to that quote?
We declined the quote of $1,850.
You were asked why you didn't contact Mason back with respect to the roof leak, the drywall crack, the timing on the dimmers. What was the reason why these issues, when they came up, you did not contact Mason to fix?
The relationship was over for all intents and purposes. At that point in time, a lien was filed on my property, $20,000, when, in our opinion, we were owed still something less than $7,000. I didn't feel it was fruitful. I didn't feel he would come. He even show up. That the relationship had deteriorated.
You had paid others to make these repairs, is that correct?
That's correct.
Now, I want to draw your attention to exhibit number 9. This is a letter that you wrote to Ms. Fifth, is that correct?
When I received, I went to the mail in Perrysburg, Ohio, and signed for a certified letter. And that's when this same day is when I first got word of the lien.
And in response to the receipt of that lien, you wrote this letter to Ms. Fisk, which is exhibit number 7. Is that correct?
Correct.
And in that letter, did you actually say to Ms. Fisk you will not pay the whole back $6,995?
No, I suggest I want to pay it, and let's get the open items resolved. And if your client is unwilling to do it, and I'll go and have it done and credit the $6,995 payments made to someone else.
You put a summary there on the last page where you outlined, is that correct?
Correct.
All right. Now, did you receive a response from Ms. Fisk to this letter?
I never received a reply.
Okay. Now, drawing your attention to exhibit number 8, you sent Mr. Mason an email, is that correct?
Correct.
And on August 31st, did you receive another invoice from Mr. Mason?
Yes, I did.
All right. And did that final invoice provide any information as to what was owed at that time?
From my memory, I would imagine it was the final $6,995.
But it's not included on an exhibit, plaintiff's exhibit number 3, is it? And Mr. Mason is telling you on that August 31st that the electrical and the plumbing inspection.
Correct.
That would be considered completion, you think, of the contractual provisions that he was supposed to supply?
Yes,
And that's August 31st, is that correct?
correct.
Based on your simple calculations, how many days is that after the lien?
30 days after the lien was filed.
If you look up above that, you emailed back on September 4th, is that correct?
Correct.
And what did you outline in your response to him on September 24th? That's exhibit 8.
We were able to visit the home, and we have a few items that we still see outstanding.
Items that are who was performed.
Mr. Mason,
Did Mr. Mason ever perform the items that were left outstanding on September 4th?
the dimmers were taken care of, the gutters were not.
And ultimately then the electrician, the furnace and AC were wired as well, is that correct?
Correct.
At this point, were you refusing to pay the $6,995?
We were not.
In fact, you indicate in there, read the last sentence there.
Please let us know the timing of items 1 and 2, as we will then make arrangements for final lien releases, removal of the lien if it has not already been done, and final payment. Thanks very much.
You wanted to pay him upon completion of his contract, is that correct?
Correct.
Drawing your attention now to exhibit 9. This is an email that you sent to Ms. Fisk, is that correct?
Yes.
And what is the purpose of this email?
I was indicating I received an email from Mr. Mason saying the gutters were fixed. I was indicating I was traveling and I was out of town, and I would get there to observe, make a final walkthrough and punch list items, water test the gutters as soon as I could get to the property.
And you're refusing to pay the $69.95, assuming Mr. Mason has completed his contract.
No, I indicate, if assuming all is in order, how do you want to proceed with us making final payment in exchange for the lien waiver, release of the $19,000? And you want, then I say I'll release the final $6,995 from Fifth Third Bank in Toledo, Ohio.
On September 11th, had you received any lien waivers?
I had not.
And you had received the finalization of the water and the electrical permits, is that correct?
That's correct.
That was August 31st?
Correct.
Okay. In response to this email, again, strike that. I apologize, strike that last question. Are you refusing to pay the $69.95 at this point in time?
I am not.
In response to your email of September 11th, you received an email that's marked as Exhibit 10, is that correct?
That's correct.
And that's from Mr. Mason, is that correct?
That's correct.
What does he indicate?
He indicates that each time I speak with his attorney, it's costing me money.
And is this the first time you understand that he's demanding attorney fees from you as well?
Yes.
And that's located in the second to last paragraph, is that correct?
Correct.
Prior to this time, had anybody made demands to you about payment of attorney fees?
They had not.
The date of this email again is what?
Thursday, September 13th, 2018.
How many days after the lien was filed?
Approximately 45 days.
Had you received any lien waivers on September 13th?
Had not.
Has there ever been a time in this project where you have received on the completion of the contract and the receipt of lien waivers to pay the $69.95?
There was not.
Describe to the court your reaction to the demand for attorney fees.
I thought a lien was filed, unnecessarily filed. There was no collection risk. I never was, I paid 86% of the 41,000 was approximately 86%. And there was maybe 10,000 of open item value when I still owed the 6,995. I was very surprised when a lien was filed. The whole reason I asked for conditional lien waivers from Mr. Mason was because I didn't want a lien filed on the property. So in my opinion, he was getting counsel as to whether he should sign lien waivers and what are lien waivers, what's a conditional lien waiver versus just a regular lien waiver. And so I was very surprised I was asked to pay legal fees. And at this point in time, I undertook my own legal counsel or hired legal counsel.
And then this suit ultimately ensued, is that correct?
That's correct.
Judge, I'll reserve the remaining questions for direct examination we put in our case. Nothing further at this time.
I have some follow-up questions, Your Honor.
Go ahead.
Mr. Jaros, you make some statements about lien waivers and continuously assert that no lien waivers were given to you in this case. Are you aware that in Michigan, subcontractors that don't have a direct contract with a homeowner are required to give a homeowner a notice of furnishing in order to secure lien rights? Do you know that or not?
Do not. Or did not.
Okay. So did you receive any notices of furnishing on this project from subcontractors?
I did not.
Okay. So you're not aware of whether or not subcontractors on this project would have even been able to file a valid lien against your project. Is that a fair assessment?
That's fair.
Okay.
That's therein lies the worry.
And in fact, no other liens were filed on your project, correct?
Right.
And we're 2.5 years post the end of the project, right?
Right.
So if I told you that the time frame had long passed for that, you don't know the answer to that, I'm assuming, but do you still have a worry to this day that someone's going to put a lien on your property?
Not to this day, I do not.
Okay, thank you. We're well past that point. Would you agree?
I agree.
Okay, thank you. You mentioned a conversation that you had with Mr. Mason on April 13th after the project had started about when the project would be done. You remember that?
Yes.
And you mentioned that Mr. Mason made a promise that you would be in by a certain date. Do you recall that?
Yes.
I'm going to have you look at Exhibit 1, page 3, which are the terms and conditions.
Okay.
Let's look at paragraph number 2 of the terms and conditions. It starts out with J. Mason Contracting LLC shall not be liable for any delay. You see that?
Yes.
And you agreed to this terms and conditions, correct?
Correct.
Now let's look back up, or I'm sorry, let's look down at the date of the change orders that were made on this project. Those would be the subsequent documents to the terms and conditions, right?
Right.
And the date on these is May 1st, correct? May 1st for one, May 9th for another, May 17th for another, May 21st for another, correct?
Correct.
And the changes that were made, we talked about, were fairly substantial. Would you agree?
I would agree.
All right, a beam was replaced underneath your house, right?
Yes.
You added a 22-foot deck on the lake side of your home, correct?
Correct.
And some additional plumbing work was added for this splitting the bathroom into 2, right?
Correct.
So we have a fair amount. Go ahead.
Ms. Fisk, let me interrupt. Is there a counterclaim or something in here that damages are due for delay in completing the contract? Is the
No, Judge.
defendant refusing to pay because of delay in completing the contract?
No,
And if
Judge.
those things aren't present, why are we wasting time on this issue?
I agree with
I
that,
want
Your
to,
Honor.
I'm going to go off the record. I want to have a off the record conversation with counsel right now. Shannon, take us off. I'm stopping the live.